Tēnā koe. Just while the group is coming up, just to explain a couple of things, there will be a karakia to begin on behalf of the iwi. Once I've done my very brief opening submissions, as I do appreciate it's the end of the day and no one wants to hear me speak, I will sit behind the panel and there'll be a panel 3 and I'll just take this down so everyone can see them. Ka pai?
Ai honoro e krori he maungorongo penu he whakara pai ki nā tangata katoa amene. Waka moi me titunu atu i a koe e ho mohamana ki tangi a mātou katoa e roto tini e pare. No re e tō matou batu o tarangi, koe te tīmata ngona mea katoa, koe anō te whakamutunga. Ka hotu atu nā whakamoi me si kā koe. E tini rā, tāhua e honga he koe a mātou i tini rā. No re e tō mātou te matua. Aloha mai rā ki a mātou. Ni rā mātou, e no hatu nei, e kōra rana ki te tepu, ani ki te karauna. Maha mātou e awhi, e runga rāwa mātou kaupapa. No rei e te atua, ko koe te o mātou atua. E whakora ia mātou katoa, kororia ki tō ingo tapu. Āmene. Kia ora te tepu, kia ora koutou katoa.
Tēnā koe, I'm at Pleaser Tribunal. Council's name is Ms. Wan. I filed opening submissions, which are 3.3.122. I don't intend to speak to them today. I just wanted to introduce the group who are the iwi of Te Upokorehe. This is, they've presented evidence in stage 1 of this inquiry. They've filed evidence, which they will now present in stage 2. They've also been part of the 8-week hearing that took place last year in the High Court, so they're hoping this is the last time they'll have to give evidence on behalf of this Act. And without further ado, I'd like to introduce the panel, which is Ms. Upokorehe Baker, Trevor Ransfield, and Paul Mare. My apologies, I've been on leave, forgotten everyone's name in the meantime, and Pop, who just did a karakia. And now I will now take my seat and let them present their evidence. Kia ora.
E te tepu, e te whānau o te takutai moana tēnā koutou katoa. Ko Upokorehe Baker tōku ingoa, ko te Upokorehe me te whakatohia o ku iwi, tēnā koutou, tēnā koutou, tēnā koutou katoa. I know everybody's had a long day and probably feeling tired. I'm not going to go through my evidence. I think I'll take that as read. I will talk to it, but what I would like to do is talk about our experience preparing for and sitting through the High Court case. For Te Upokorehe, we had not experienced a High Court case. We have not experienced a historical hearing. So all of a sudden we're precipitated into a tortuous legal environment. And it is an environment that judges and interprets our tikanga, our history, our wahitapu. Everything that we hold dear as part of us gets laid before the courts and the judge gets to determine. And he does so from the basis of an act that is cherry-picked tikanga, because when you have a look at that act, it's full of kaitiakitanga, manaakitanga, where's rangatiratanga? Our experience is you cannot have one without the other. Now, when we knew we had to file our research, we did 2 things. Everybody gets funding for historical research and funding for cultural research. Well, we hired a historian, a legal historian, because we knew we needed it, and I will tell you why. But when it came to collecting the cultural research, that was our people. Our kaumata went out all around Arohi. They visited 123 wahitapu. They did not download that from ArcSite. They did not download that from Google search. That was their kōrero. It is their mātauranga, and they are the experts that hold this. It was a very difficult thing to do. We're told we have to do this to protect our waihi tapu. And yet here we are having to put that before the court. We've got no control over that. We've got no control over how the judge is going to interpret that or what protection might look like. So if I move on to once we've done that and we're in the High Court, and it went for, I think, 9 weeks or something, and we were about the last week up. And it was very evident to Upokorehe that the Act, had really enabled total overclaiming. Now, to Upokorehe, we are Te Hapu Onioni. We claimed our rohi moana. We claimed from Marae Tōtara in the west, the Marae Tōtara River, to the mouth of the Waiweka or Pākahi Kura in the east. Of course, we've fished beyond that, but we do not hold mana whenua mana moana there. We did not claim there. We have no interest in what anybody else does beyond our rohi. That is not our business. So what we were confronted with, because the Act brought about a do or die feeling amongst claimants, you had to claim everything. So we claimed our rohi and we were overclaimed. And we noticed that it was a rerun of the 1898 Native Land Court case. That was very hard for our people, and if I turn back the clock, you'll remember what it was like, those of you who may not, you wouldn't have been alive then, but history tells us that when Upokorehe were given hiwaro, the hiwaro reserve by the Crown, that was meant to be for Upokorehe, but we know that at the time the Crown was chasing Te Kooti, and the Crown was trying to curry favour with Raku and with Kākatu. And here's land that they're going to award. So on the one hand, they say this will be for the Upokorehe tribe, but when they get to awarding it, these people put in there that have come through Raku and Kākatu. And of course everybody claimed, because if you didn't have land, you couldn't grow food, you couldn't live. If you couldn't catch your kai, you couldn't live. Everybody overclaimed in the 1800s. We sat through another one. We sat through a rerun of 1898. So you can imagine how that was. We have come out of that feeling it could be worse than we are now. We have looked after the Ohiwa Harbour and our rohi mai rāno. I opened my submissions to the High Court talking about Rick McGovern Wilson, who was an archaeologist. And in 1996, Rick McGovern Wilson excavated a site called Tukituki. It was Upokorehe that informed him the site was Tukituki, and it was Upokorehe that held the knowledge of that site. From Rick's point of view, that was highly significant because the site itself is the only site sitting on the Kaharoa, immediately on the Kaharoa ash, following the Kaharoa eruption in 1314, and is an extensive living site. Upokorehe participated in the excavation and gave extensive interviews. And Rick McGovern Wilson said, and I quote him, that the degree of tribal knowledge given by Upokorehe kaumātua has not been collated for any other site or any other landform in the Bay of Plenty. So Upokorehe, we aren't interested in claiming beyond. We have never claimed beyond. Our relationships with all our people around us are very old relationships. We have a marae that we built called Tūranga Pikitoi. We built it for our tūhoi whānau when they came through to gather kai at Ohiwa under the mana of Upokorehe. So from Upokorehe's point of view, do not mistake manaakitanga for not having mana whenua. Upokorehe have the mana whenua to determine the use of our harbour. We've done that mai rāno, we do that today, we continue to do that today. We have long-standing relationships with Regional Council and with DOC. They go back many years. Our people have been working, looking after their rohi for many years. So what's the Act actually going to give us? It's going to be more of a headache than anything else because it's open cross-claiming. Right now it is Upokorehe that look after our rohi. When we had 40 pilot whales beach at the Ohiwa Harbour, our kaumātua invited others to come and learn from the tohunga tohora on how to remove those upoko. So Upokorehe, we removed all 40 of them and we've kept them for research purposes. That's just one example. Over the Christmas, a notice went out on Facebook by one of the whānau. Hey whānau, let's get down there and let's monitor the pipi over the Christmas break. We're not waiting for anyone to tell us we can do it. Our whānau just do it. They always have. So what we're looking at is coming out of a High Court hearing that could be worse than what we've got right now. It doesn't seem to us that the Act actively provides for joint exclusivity. It might not impede it, but there's a world of difference between not impeding and actively protecting and actively enabling. So our experience has not been a very pleasant one. To have to sit through the equivalent of an 1898 Native Land Court hearing is not something that I feel our people should have been subjected to. It has taken a lot out of our kaumātua. You'll see we don't have a full team here today. Some of them are still recovering from that experience. And the other thing that happened, and once again we believe this was enabled by the Act because of the over-claiming, other claimant groups had filed their version of our whakapapa. That had been filed and accepted. Now our kaumātua had to save us at the 11th hour by putting our whakapapa down in front of the court. He didn't want to do that. We had not filed it. We did not know others were going to file that whakapapa late. It was a misrepresentation of our whakapapa. And that was brought about through enabling overclaiming. And of course, if you turn the clock back to the 1800s mentality, everybody using whatever they can to claim. And that's what we're facing. So at the 11th hour, our kaumātua had to put his whakapapa down in front of the court to counter whakapapa, Upokorehe whakapapa filed by others and misrepresented. I think that is probably all I can think of at present in terms of our experience, but I'm welcome questions on it because it was not something our people should have been subjected to.
Thank you, Kahukore. If everyone can remain seated, I believe there's questions from Mr. Melvin from the Crown and any questions from the panel. Kia ora.
Tēnā koutou, ngā mihi, thank you for your evidence. My questions really focus on the issue of wāhi tapu protection, which has been covered in the brief of evidence. And the evidence raises concerns about having to disclose information about wāhi tapu in order to protect them. Would you accept that there are other mechanisms outside the Takatamuana Act that, or by which wāhi tapu can be protected?
The only mechanisms, is that all? Kia ora. The only mechanisms I'm aware of are the ones our people do. It's their customary practices.
Right, so you're not aware of provisions under the Heritage New Zealand Pouhere Taonga Act, for example?
Once again, it comes down to how our people are engaged under that, and regardless, it relies on the customary knowledge of our people to do that. So a piece of paper may say one thing, an act may say one thing, but making it real relies on the customary knowledge of our people. So I don't accept that the way the Act is written or other provisions actually do that. And that's why our people have not put that knowledge out before in any forum. They also only listed 50% of our wahi tapu because we were very concerned, and our kaumata were very concerned, that our customary knowledge would be misinterpreted or misappropriated by others once it was in writing.
So there is no obligation under the Act to disclose wahi tapu, is there?
You don't have a choice when you're looking at a Taku Tamuana Act. The Act is all or nothing. You don't have a choice because others could very well put in your wahi tapu as theirs.
Well, I understood you to say that there were wahi tapu that you did not disclose.
We chose not to.
Yes. So there is an element of choice as to whether information is disclosed in that process.
It's not free choice.
Do you accept that the court may be able to put controls on access to and use of sensitive information?
Not really. Just because the court may determine it doesn't mean to say it'll happen. Is the court going to stand over every time somebody reads it, every time somebody downloads it? No, I don't accept that.
Well, how do you propose to resolve the conundrum that exists in terms of seeking protection of wahi tapu on the one hand and the desire not to disclose information about wahi tapu?
There is no resolution. We just did what we could do, which is not to declare 50% of them, but we still believe the 50% were the ones that we put in are vulnerable.
So you acknowledge that it's a difficult issue that has no ready answer?
It has no resolution under the Act, no.
Well, I'm asking you to consider looking beyond the current provisions of the Act to see whether you can identify a resolution.
If we're looking for a resolution to the fact we have identified 123 wahi tapu and that is sitting in the High Court records, all I can tell you is we are very vulnerable in that position and we do not feel assured by any ruling.
I understand that Te Upokorehe and the Bay of Plenty Regional Council have entered into a memorandum of understanding regarding Onekawa Te Mawhai Regional Park.
Yes, that's correct.
And there's a draft Onekawa Te Mawhai Regional Park Operational Management Plan.
Yes.
I believe that was put in place in September 2014.
Yes, and the MOU talks about recognising the significance of the site Te Upokorehe. However, the areas where we do have the odd agreement, and I say the odd agreement, where, and I want to take a step back here and look at the impact on Upokorehe, because we have not had our historical hearing yet. So whatever judgment the court makes, if the court comes out with a judgment that they're going to bring others into our rohi, we know that's going to influence the historical hearing and we know that's going to influence the negotiations taking place. They can't be divorced.
So just coming to back to that draft management plan, there's a provision in it to place signage in appropriate locations to identify restrictions, inform and direct visitors and provide educational opportunities. This is to include any restricted areas such as wāhi tapu sites agreed and identified by Upokorehe.
That's one
So-
site, yes.
Well, it's I think what I've just read out applies as a general provision. It's under the heading Implementation for Visitor Experience.
That's
So-
for the sites, the wāhi tapu sites around Onikawa. I'm talking
Yes.
about throughout Arohi, from Marae Tōtara to Waiweka.
So, in some circumstances, it appears Upokorehe is willing or has a level of comfort to identify wāhi tapu. Is that a correct conclusion to draw?
Well, we're sitting in a position where that could, for all we know, that could wind up being given to whakatōhea. So, no.
I think you've misunderstood my...
No, I haven't. What I'm saying is you cannot divorce the taku tai moana or the fact that, yes, we do have an MOU for one site. We do have that at present, but the Crown is once again negotiating with a neighbouring iwi, and all our lands are on the table as redress for whakatōhea. That will include that.
One last final point. At paragraph 4 of your brief of evidence, you, Ms. Baker, talk about filing your application under the Act on the very day that the statutory deadline expired. And I was wondering why it was left to the very last day to do that. Because, as you've made it plain, the takatai moana is a matter of fundamental importance to Upokorehe. Am I right about that?
It is.
And had Te Upokorehe opposed the Foreshore and Seabed Act?
I can't remember. When was that?
Well, it was introduced in 2004.
If that meant did we come to the tribunal to oppose? No.
Te Upokorehe may have made submissions to Parliament about it, but perhaps you don't remember.
No, I don't.
Given the fundamental importance of the takatai moana, were Te Upokorehe not aware of the introduction of the Takatai Moana Act in 2011?
Being aware of it and understanding it are two very different things. What we're looking at is an act that is operating at a level way above what our people are used to. Now, when that act came in, the Crown didn't come and consult with Te Upokorehe. The Crown didn't come and talk to us about what the implications were. When we finally filed, and what I think the Crown really does need to appreciate is for Upokorehe to file their own mātauranga is crossing a very wide cultural gap and a very long piece of time. We have had nothing but trouble ever since the Raupatu. We have not had redress. We have not had reserves for Upokorehe. They were given to others. So whatever Upokorehe has been able to secure, they've had to fight for themselves. So it is hardly surprising our people were very, very reluctant to file the type of knowledge that was required for this claim. There
were a a number of hui around the country following the introduction of the Act. Did Te Upokorehe not take part in those?
We were too busy fighting the cross-claims issues with the Tūhoe settlement.
Ngā mihi, kia ora. Thank you for your answers. Thank you, sir.
Kia ora, Ms Baker. I just was interested to know, in terms of the High Court proceedings, were there a number of other claimants who made claims for protection of wahitapu sites within your claim area before the High Court, or was it Upokorehe only who sought protection of wahitapu status?
I think others may have done so, but not to the extent we did.
And only one other question, just in the course of those proceedings, was there any reference to a pukenga to assist with mediation, or
Yes, there was.
And was that successful or not?
We had already met with pukenga, taken them around our rohi, and we met with 4 cross-claims groups, and we wanted to meet with them just group to group rather than with the pukenga. We said to the other groups, if you wish to bring the pukenga in kei te pai, we're quite happy just to sit down and court it all. So we met with 4 other groups over one weekend to do that.
And was that a successful process or not?
Well, with one of them, with Ngāi Tai Whakaia, it was. Upokorehe and Ngāi Tai Whakaia recognise each other on the western boundary of Marae Tōtara, and we talked about deepening that relationship going forward by both groups developing a relationship agreement where we work together to tautoko each other on that boundary. Other groups we had discussions with, and with one of them they're still ongoing.
And, sorry, there is one other matter. The management plan that Mr Melbourne was asking you about, you said related to one particular locality. Where is that locality?
Onikawa Te Mawhai, it's, don't have a map, but it's up on a headland, and I think what I will do, I'll hand over to the kaumātua to tell you as best we know to describe where that might be, because I don't have a map to show you.
Right.
Onikawa Te Mawhai, Trev.
Kia ora te tebo. Onikawa Te Mawhai Par site is above the Ohiwa camp. Upon the headlands, as Kahukore said, it overlooks the entrance to Ohiwa Harbour.
Yeah, I thought that might have been the location. Was that one affected by a major slip some decades ago?
Yep. And just last week, we just finished a yearly inspection with the Regional Council on Onikawa as a reserve. And that we do that every year, as in the management of that historical reserve, that par site.
But that par site, I take it, wasn't destroyed by that slip.
Pardon?
That par site wasn't destroyed by that historic slip. Or there was a major slip, as I understood it, that occurred some time ago.
No.
No? Right. Thank you.
Finish him off.
Yeah, closely with the karakia, tepu, thank you. E te honore ko e mongo te penu parapai ki ngā tangata katoa. Ko moe mistuna ti a koe ho maha mata manaki I tēnira. Maha ra mata ara he runga te huarai. Te huarai tika, te huarai pai. Nō re e tō mata mata trau ko koe te atua. E api a mātou e nā wā katoa. Nō re e tō matua. Honore ki tō ingo tapu. Amen. Kia ora. Kia ora. Koutou.